All right, everyone. We're going to go ahead and get started. Good afternoon, and thanks for coming. Welcome to Planning for the Future, Workforce Risk Transfer and Legal Guardrails. I'd like to thank you for coming and welcome you on behalf of Reinhart, Borner Van Dieren. I'm Michael Gentry, one of our shareholders in the Labor and Employment Department. Reinhart is a full-service law firm with a business-oriented law firm with offices in Wisconsin, Illinois, Minnesota, Colorado, and Arizona. And we have more than 200 attorneys across clients across the country and internationally. We're glad to have you here with us today for today's discussion, with which we're hosting in collaboration with Mosaic Financial Partners. And on that note, it's now my pleasure to introduce Andrew Bird. Andy is a certified financial planner and has been with Northwestern Mutual since 2004. In 2019, he and his partners co-founded Mosaic Financial Partners, a specialty team within Northwestern Mutual. Mosaic has been recognized as a Forbes Best in-state wealth management team, and Andy has been named a Forbes Best in-state wealth advisor. But Andy is especially proud that Mosaic was recently ranked a best place to work by the Milwaukee Business Journal in 2025. Andy is a wealth management advisor at Mosaic Financial Group, and he and his wife, Ginny, live in Fox Point with their 4 kids. Please join me in welcoming Andy.
All right. Super excited to be here. Thanks, everybody. Thank you, Michael. Thank you, Reinhart, for hosting. And I know we started a little bit late. We're just trying to see what people might have got stuck in traffic. So I'll try to make this a little bit quick, but I won't rush it. Just so we can make up for lost time, because of course we're standing between you all and the bar over there. So I also want to give a shout out to Michael, who's done a great job as Mosaic's labor and employment attorney. And we just think really highly of Reinhart in general. Also, our firm sends out a lot of estate planning referrals, and a lot of them do end up coming Reinhart's way as well. So I'm going to focus today on how to keep top talent on your team. So that's going to be my focus. He's obviously going to talk about all the legal stuff. That's not my area. So we're going to talk about how do we retain top talent, protect your business against the loss of key people, buy-sell planning for business owners, and ways to fund deferred compensation or reposition corporate assets for more efficient growth. And I would also just say, especially with our smaller group, just please ask questions as we go. I mean, I'll give you time at the end and also after, but by all means, ask questions. Except for my team members who are here, you can't ask questions, sorry. So first off, I just want to talk about the cost of losing a key employee. If anybody had to guess, what do you think it costs if you lose a key employee? And we'll say it as a percentage of their salary. 10%, 50, 100, 200. What would you guess? Okay, 30? Okay. It's 50 to 200% of someone's salary. Now, I would also tell you it's the higher end positions, the executives, where it's really going to sting the most, because it's really hard to replace, say, a CFO or a COO or something like that. And so it could really add up. All the recruiting costs to hire that new person, the lost productivity. So it's pretty big, to the point where I was supposed to ask you this, but here's the answer. $600 billion is the total cost in lost productivity, according to the Society for HR Resource Management. Of voluntary turnover annually in the United States. So it's a big number. So I think the question is, are your key employees' compensation and benefits plans up to par to keep them? That's really the major focus here. And if not, how can we do that? So first thing I'll just share is you've got to make sure that all the basics are done right first, okay? So you've got to be paying a competitive salary, competitive bonus, got to have a competitive bonus benefits package, 401k, group disability, group life, all those things they're table stakes, okay? And if you're a publicly traded company, stock benefits, that's pretty common as well. But if you're a privately held company, that gets a lot more complicated, because a lot of times owners don't want to give away equity. And so some of these ideas are especially beneficial for privately held companies, but they can also work for public companies too. What we're typically talking about key employees is your top 10 to 20% of employees. So how do we ensure that they stay with you? A couple of options are deferred bonus plans and executive retirement bonus plans that we're going to talk about, also called supplemental executive retirement plans, or you might have heard them called SERPs for short. Okay. So first, I'm going to talk about the short-term deferred bonus plans, and these are pretty simple. What I want to do is start by differentiating from, say, a qualified plan like a 401k. So qualified plans have a lot of benefits, such as if a company ever goes bankrupt, your employees' 401k balances are protected, right? If you're familiar with deferred compensation plans, typically those are not protected assets if a company goes bankrupt. And that's the downside of non-qualified plans. So very similar to deferred compensation here. Any assets that you might set aside for this short-term deferred bonus plan is a general obligation of the company and can go away. So that's the downside. I always like to end on a positive note. So what's the upside? You can pretty much do, I don't have many attorneys in the room aside from Michael here, whatever you want. There's a ton of flexibility in what you can create for people. So that's the trade-off, okay? When we're talking about short-term deferred bonus plans, we're typically talking about a 3 to 5 year plan. It can be shorter, it can be longer. And what we're typically talking about is if it's a 3 year plan, we're probably going to be paying out at least 30% of their total comp at the end of that period of time. And if it's 5 years, 50%. But it could be more, it could be less. There's no extreme magic to that. It's just what we are commonly seeing being implemented that we're helping our clients put into place. So what it looks like is, let's just say you have somebody making 100,000 a year. You might say, hey, Michael, if you stay here, you're so key. In 3 years, I'm going to give you $30,000, or in 5 years, I'm going to give you 50,000. Or if you're making $1 million, it's going to be 500,000 in 5 years. One of the other nice things you could do to protect your business is at the same time that you're putting this in place, you can typically also get a non-solicit and non-recruit signed. I would say non-compete, but as far as I understand, they're not legal right now. Is that correct?
It depends.
It depends. All right, he'll get to that later. Okay. So, and the reason why I think this is important is non-solicits and non-recruits, at least according to the counsel we've received, you can't just ask an employee to sign. You have to give them some consideration. So this would be a great time to do it if you're going to be setting up these bonus plans. I see a few of our team members looking at me going, oh, that's what you were doing there, huh? But anyways, so that's what a short-term bonus plan is. And you don't have to fund it. You could just let it be a general obligation of the company and plan to pay it out of cash flow. But as a former CFO of Mosaic, I would say, and as I think any CFO I've ever talked to, it's not a good idea to just have an unfunded liability on the books. Would you all agree with that? Okay. So even if we can't officially tie an asset to this bonus plan, we should be doing something informally. Does that make sense? So we typically call it informal funding of a bonus plan. And I'm going to talk about some ways to fund it, but does anybody have any questions so far? Okay. So if we're just talking 3 to 5 years, frankly, you don't need to get too fancy here. You're probably just talking about cash or cash equivalents. So I'm thinking money market, CDs, something along those lines. If we get out to 4 to 5 years, we might want to start building in investments. This is where we're typically looking at a diversified portfolio, maybe what we call a 60-40 investment portfolio, or something that has some bonds in it. And we typically use 5 years. On average, the stock markets have a bear market roughly every 5 years. So if we're using investments and it's all in stocks, what if we happen to catch the timing of this bonus to coincide with the bear market, right? Back in 08, we saw roughly a 40 to 50% drop, depending which markets you're talking about. We don't want that to coincide with the bonus payout. You can also mix and match those two. But that's what a short-term deferred bonus plan is, and that's how we typically fund it, okay? Supplemental executive retirement plans, or just long-term bonus plans, are typically 10 to 15 years, or we tie it into a certain age, such as 65 or 62, or whatever you want to make that person's retirement age, okay? However long you want to make sure that person is with the company. So same concept as before, and you could layer this on top of a short-term deferred bonus plan, okay? So you can have both for the same person. You might say, why would I do that, by the way? Well, let's just say Michael's case, it's 20 years until he's going to retire. It's a long time to wait, even if it's a big chunk of money. So you might say, hey, you know what? We'll do something every 3 years, kind of on a rolling basis to keep him excited on a short-term basis. But we're also going to have a really big pot of gold at the end of the rainbow too, with our favorite holiday coming up for some people here. So, okay. Same rules apply as to who you can set this up for. And I apologize, I didn't talk about this on the last slide. You can't set these up for just anybody at the company either. Okay. So typically, both short term and long term bonus plans, you have to do for a certain group of people. Okay. So if we're talking about an executive leadership team, no problem. If we're talking about maybe let's call it mid-level managers and above, no problem. No offense to anybody in the room who is a janitor or has janitors in their family. If we want to do some janitors, it's probably not going to happen. Okay. In fact, Walmart got in trouble for trying to do that in years past. Okay. So we're typically talking about certain groups of employees we can do this for. And it's the same for the short term and the long term. But as we get into longer term, 10 to 15 years, cash and investments are still an option, but you can also use permanent life insurance. Okay. And here's the elephant in the room. You're like, oh, okay, here's the Northwestern Mutual guy talking about life insurance again, right? But I'll make a couple caveats to that. One is biggest reason people are doing it is for the tax benefits and some of the additional benefits that you don't get with investments. So I'll walk through that. And secondly, it doesn't have to be exclusive. You can mix and match all of these. Okay. And then the other thing I'll say is the first illustration I'm going to show you, I hope you have good eyes, but I'll try to just talk it out loud as well, is kind of more the traditional, I'm going to call it retail life insurance that you might have seen in your own personal lives before. But it's still pretty compelling on its own. I'm going to have another slide sharing a different version called corporate owned life insurance. And if you haven't seen that before, which is my experience, most people haven't, that one's really interesting and different. Okay. So before I show you an illustration, why permanent life insurance at all? And I'm going to first say, why not? And why didn't I mention this for anything short term? So if any of you are familiar with what I would just call personal or retail life insurance, the reason why not is from a cash perspective, typically what you put in is not going to equal what you can get out for at least about 7 or 8 years. Has anybody seen illustrations like that before? And sometimes it's longer depending how you design it. So that's one of the reasons why we wouldn't want to use it for a 3 to 5 year bonus. But if we're talking 10 to 15 years, we can actually get some nice growth on these policies and we could add life insurance. And you might say, why would I want to add life insurance? Well, now there's two things that we can do that we can't do with investments and cash. We can now set up a key person benefit to the company. Okay, so if you think about it, if we just start putting away $10,000 a year into an investment account, how much do we have after 1 year? 10,000 plus some growth, right? Maybe if we got 10%, we have 11,000 bucks. But if we put $10,000 into a life insurance policy, we might have a $400,000 life insurance policy. And if this person dies, the company can get a big portion of that death benefit. So now we have a key person benefit protecting the company. So let's imagine this person is a key salesperson, or maybe they have intellectual talents or capabilities that it's just going to be really hard to replace. Okay. Think of maybe your best programmer or something like that. That can help insulate the business against the risk of that key person dying. Does that make sense? But we can also now add an extra benefit to that employee's family and give them some extra life insurance too. So those are some of the reasons why life insurance may make sense, even what I'm going to call the old boring retail life insurance, which is what I'm about to show you. So, but even in this, and again, numbers are going to be hard for you all to see. Can I move this thing around? Looks like I can. Okay, great. Because you're probably not going to be able to see the numbers great from back there. You're all welcome to move up if you want. But what I just wanted to show you was, and I used Andy Bird as an example. If you wanted to put $10,000 a year into a 42-year-old, it would buy $400,000 of death benefit. And what I'm showing here is you're splitting that death benefit. 200 goes to the employer, 200 goes to the employee. Okay, so now that's a death benefit that, again, we wouldn't have with investments or cash. Now, on the money in, money out. So column 3 says, what's the total amount we've put in? 10 grand is what I'm illustrating here in year 1. 5 grand is what we can get out. So again, as a short-term investment, really bad. Investment guys in the room would agree with that, right? That's like a negative 50% return, I think. But let's take a look at a couple of years out. I looked at about 8 years in. You've put in 90 and it's worth 91. Still not that exciting, but at least you broke even, okay? If we get to 15 years, and I'm assuming that this is a supplemental executive retirement plan that we're funding for 15 years, now we've put in 150 and there's 193. And we're always careful. We're not trying to compete with investments here. This is for the money that maybe somebody would have otherwise put in cash or bonds. And when we look at long-term rates of return on this, especially on a tax equivalent basis, we're typically seeing anywhere from 4 to 6% returns, which is not the stock market returns for sure, but it's a lot higher than short-term savings account returns too. A couple other things I want to mention that are key differentiators between those other options. This cash accumulated value, they'll either call it that or cash value, grows tax deferred. Whereas money in a savings account or money market or CD or even an investment account is going to get taxed as it grows. So if we get $3,000 of interest on a savings account, you're going to probably, assuming a 33% tax bracket, you're going to give up a third of that. Whereas this is not getting taxed as it grows. So even though initially it's a little weak, on the long run, that tax advantage really pays off. Because if we have 193,000 here, let's say we have it in an investment account instead that maybe has 220,000. Well, there's going to be some capital gains in there, and we're going to have to pay a capital gains tax on that we don't have to in here. Does that make sense? Any questions about that at all so far? I don't mean to paint this as a silver bullet because it's not, but I think this, especially mixed with investments and cash, can be a really great option. And what we're also showing is at age 58, we're paying out that 150,000 to that person, or we're taking a distribution from that policy. And there's actually still $72,000 left over as well that we could either retain as a company or we could give to that person. The policy actually doesn't end. And the last point I'd want to make is this is a corporate asset. Even though initially it's a little bit less than what we're putting in, the company can borrow 90% of that at any time for any reason. So it's not like it's all inaccessible until the end. So does that make sense? Questions at all? I'm waiting for these finance guys over here to grill me. So, okay, just wait. It'll happen. All right. I'm going to come back to this buy-sell planning. I think it's important, but I realized after I put this presentation together, it just made more sense if I flowed this way. So what I want to talk about now is funding deferred compensation or repositioning treasury assets. So one of the things I've noticed in working with a lot of business owners over the years is if they have deferred compensation, what I typically see it being funded by is cash, maybe cash equivalents, so CDs, money markets, and sometimes mutual funds, ETFs, index funds. So again, I kind of already mentioned one of the downsides is tax inefficiency there, right? And especially on cash, you're just not getting a high yield. So yes, again, I'm going to bring up the idea of life insurance, but in a different format here as a better way to reposition that. Now, the other thing I've seen is, I'll just tell you a story to illustrate the point, is a lot of companies that are just sitting on a good amount of cash as a rainy day fund or a future acquisition fund. So I work in the personal planning markets as well, and I happen to work with a lot of accountants, a number of whom are CFOs. And I was meeting with a CFO client of mine about 5 years ago, and I asked if they had any, life insurance in their company. And he had once worked at another big corporation, said, I've kind of seen that. I'm not really interested. It wasn't really exciting for our company. I was like, well, this might be a little bit different. Can we take a look at it? And because that company, about 200 to 300 employees at any given time, was always just sitting on 5 to 7 million in cash. And this was like 5 years ago when cash was not earning what it is today. Okay. So you can imagine earning 1.5% to 2%, 5 to 7 million, and getting taxed on it just to kind of have it around. It's just not really a compelling return. So I said, what if we could reposition that? And those assets would be balance sheet positive day one and accretive on day one. And those are the two key words for especially public companies. You can't have this go down in value on day one, and it needs to be balance sheet and cash flow positive. So we showed them this idea, which I'll show you here in a second. And long story short, they went from, I don't think this is a good idea, to they're putting 500,000 a year into this product, and they have been for now 3 years. And the goal is to do that for 10 years, reposition 5 million of that. Why did they do it? Instead of just earning whatever cash was earning and getting taxed on it, now we're looking at a return of 5 to 6% tax equivalent yield plus death benefit, which they didn't really need, but now all the executives have it. And now we also have some key person planning for all of those executives as well that benefits and protects the company. So that was pretty neat. And by the way, they can still borrow against that up to 90% at very low interest rates, and they can use that as still their rainy day fund or for acquisitions. So I'll jump into the illustration here in a second, but if you have any questions, just let me know. And by the way, I don't recommend that this is the only thing people should fund deferred comp with. Again, I think this is like, let's blend this with some other things, including investments. I shared earlier with some other people at Mosaic, actually about 80% of our revenue comes from managing investments. And I share that with you just so you don't think we're just this insurance warehouse and that's all we do. It's just one of these things where I've noticed in the business market, again, due to tax efficiencies, there can be some really exciting cases where it can come in handy. I've called in the what I showed you already, the retail, the individual life insurance space. I call that a get rich slow scheme. It's not get rich quick, that's for sure. But in the corporate owned life insurance, it looks quite different. And again, I'll show you that here in a second. So, and one thing I just don't want to forget to say, everything I'm showing you today is what's called general account life insurance. It's based on Northwestern Mutual's AAA rated $300 billion assets. It's guaranteed to go up every year. It can't go down. But Northwestern does offer versions of this that are more aggressive, that are variable, that we could basically pick indexes like the S&P 500 or the international, and we could let these accounts potentially grow more, but then we're going to also have more risk as well. So long story short, what I'm showing here and the key things about corporate owned life insurance and how this is different from retail life insurance is first, it's guaranteed issue. Has anybody here ever gone through the life insurance process of getting underwritten for life insurance? Right? You got to get a medical, you got to do all this stuff. It's a real pain in the neck. And with this, we don't have to do that at all. As long as we have 10 or more executives or whoever it is that we're insuring at a company, guaranteed issue. So that's key thing one. Key thing two is it's cash value break even in year one. And if this happened in the individual market, I think that Mosaic would sell a lot more life insurance. But anyways, if you put in 100, by the end of the year, it grows to 102. Now, that's not super exciting out of the gates, but at least it's not a negative number, right? It's a lot better than what I showed you a few pages ago. And we're showing putting in 100,000 for 10 years. That's $1 million. So probably talking about a company similar to the case I was sharing with you earlier. Now, you wouldn't just do this on one person. This is on one. You would do it on 10 people at least. So that would be $1 million. But you can scale this. If you cut it in half, it would be half. Quarter would be a quarter. Double would be double. Okay. And that so would the death benefit. For 100,000, it gets $1.3 million of coverage on a 55-year-old male. And a couple key things I would just point out about it. They're showing 500,000 that would go to the employee's family if they were to pass away, and the company picks up the difference. So the company would have 800,000 of key person insurance, which would eventually also grow. So again, investments are great. God forbid this person dies early, though. This is going to pay out a lot more than any investments or cash would. Okay, so that's one of the extra benefits of the life insurance. But I think, again, one of the nice things is we just look out at, okay, 10 years in, we've put in $1 million. It's worth 1.114 million. Again, I think it's going to, at that point, be very competitive with cash equivalents and bonds. And you still have life insurance. Now what's happening, you don't fund it anymore. It just keeps growing. And what we're showing is kicking out $1 million someday, probably to that key employee. And there's also still some coverage left over. But I should also mention that's not what every company does with these policies. In fact, I should have shared this stat up front. 80% of all banks in the country do this idea on their executives. And about 70% of all Fortune 1000 companies do this on their key executives for all the reasons I've just laid out there. But what a lot of them do is they keep it on those employees until they die. I know that might sound morbid. Does that mean that you have all these ex-employees who are running around still insured by the company? Yes, that is what it means. So why would a company do that? Well, if you think about it, I mentioned it grows tax deferred. You can borrow against it, tax favored. Life insurance also pays out income tax free. So if we basically keep this until somebody dies, everything's tax free, like a Roth, if you're familiar with Roth IRAs, but on a much larger scale. And if we're using this to fund something like a supplemental executive retirement plan or something like that, basically it just keeps on recuperating all the costs of what you ever put into this program tax-free. So think of some of the big companies in our country, and I'll think of a friend across the lake, my hometown state, Michigan. Steelcase is a client of Northwestern Mutuals, and I'm not sharing anything that's they've basically given all their stuff and say, you could share this with our clients. They've been doing this stuff for a long time, multiple generations. And that's exactly how they've got their setup. And there's a lot of companies that are like that, including the one that I set up here a couple of years ago. They're not rolling out the money to the employees. They are giving them some death benefit along the way, but it's just a very tax efficient way for them to reposition assets get a AAA rated company to give them a better return that they were getting on a tax favored basis. So I think that's the main thing I wanted to share with you about this concept. But does anybody have any questions at all? I will be also at the bar after because I know this is so exciting and we're going to have to talk about it over cocktails. I'm so much fun at cocktail parties, by the way. People love to talk to me about this stuff. Last thing I'll share with you, and I think this is super important, and I've got some folders that'll stick out on the table for this because this one's a little bit complex. Maybe it's actually less complex than what I just showed you, but this is especially important for businesses that are not publicly traded. Okay, so all businesses are owned by somebody unless you're a nonprofit. So let's say you have a business that has two owners. What happens if one of them dies? Well, almost every business has an operating agreement, and there's a section called buy sell. And the buy sell spells out what happens if somebody dies, gets disabled, or wants to retire. Is everybody familiar with these? Okay. Well, what I've seen in the marketplace is that first off, most buy sells are not funded at all, meaning that there's no insurance that pays out if somebody dies. So that's kind of area of opportunity one, which is if you don't have anything, you could at least get term insurance. It can be so cheap. I literally a couple of years ago, I had this marketing client out of Tennessee. They're killing it. I mean, I think their revenue was like 3 or 4 million, and that was only 5, 6 years into the business. I mean, just growing by leaps and bounds. The business was valued quite a bit, but they had nothing on each other. And it's like, well, good luck going to the bank and trying to say, I'd like to borrow $2 or $3 million to buy out my partner who just died, who was a key person of my firm, right? So the idea is you can get insurance for this. And again, term for them, I mean, it was a couple $1,000s a year because they're young and healthy. So you can solve this issue pretty quick. There's also insurance for what's called disability buyout, just what it sounds like. If somebody gets sick or injured and can't work, instead of having an odd conversation about what's fair in that situation, we could just have a policy that says, hey, you know what? 12 months in, this policy says you're disabled. This policy is going to pay you X amount of money for me to just buy you out. You're not an owner anymore. I've seen some sad situations where people don't have that, and there's some weird situations where all of a sudden you've got this owner who's not bringing anything to the table anymore because they're out of work, and it's like, can I keep drawing a salary? And it's like, well, we can't really afford to pay you anymore, right? So this can help with that. Also, sometimes permanent life insurance, like I showed, can make sense, especially if part of an exit plan. Like I see this a lot of times in families. Let's say you have parents who are going to sell to a kid someday. Well, maybe then the policies on the parents should be permanent, and that can help with the kids in the buyout in the future. I actually own a permanent policy on one of my business partners who's older than me that I know I'm going to have to buy out someday. So I figured, well, this is a good way for me to save some money to eventually buy him out, and I got to carry the coverage anyways. But the real reason I bring this up, if any of you have buy sell insurance policies in place, there was a big Supreme Court case that came up 3 years ago that if you aren't aware of it, you want to be aware of it and talk to your attorney about it. And it's called the Connolly Rule. Has anybody heard of this Connolly Rule? Great, I'm the only dork. Great. So the Connolly Rule basically said this. If you have a situation, I'll just tell you the story. There's two brothers. They both own this company. I think the company is probably worth 10 million bucks. The brothers had an agreement that if one of them died, the company would be worth 3 million, and the company owned $3 million of life insurance on both of them. And they basically said, if we die, we're going to take that 3 million and buy the other brother out. You all with me on that so far? Here's where things got sticky. They said that would be the fair value of the business. Well, the IRS chose differently. And they said that's not a fair value for your business. 3 million is not enough. It needs to be valued differently than just whatever you say it is. So that was issue one. Issue two, in that scenario, the life insurance death benefit, the 3 million that paid out when brother B, let's call him, died, now gets added back to the value of the business. So the business that was worth 10 million now just became worth 13 million overnight. Now, why is that relevant? This guy was on the edge of the estate tax, which right now is a very high number. It's about 15 million for an individual. But all of a sudden, this guy who was going to have no estate tax all of a sudden owed over $1 million in estate taxes because the value of that life insurance got added back to his estate. Okay. It's very confusing, I know. Last slide is on the left explains what the entity purchase is and how theirs was set up. On the right is one example of how you could fix it. So in the essence of saving time, if this applies to you, I've got these folders out here and I've got 2 handouts on it, okay? If it doesn't apply to you, you can forget about it. Don't use up your precious brain power. There's also something, let's say you have 10 owners or 20 owners. The one on the right doesn't work great. And then you're going to want to set up what's called like an entity cross purchase or an LLC or something like that. So there are options. You want to talk to your wonderful Reinhart attorneys about this concept if it is a problem. So with that, I think I've covered everything. And like I said, I'll be around after over drinks to answer any questions that anybody has. But any questions at all right now? Awesome. Let me introduce Michael here. If I could just get this back in. So, of course, Michael here is with Reinhart, our wonderful host. I'll give you a little bit of background on him. He's a shareholder in Reinhart's labor and employment practice. He works with clients on a wide range of workforce issues, helping them navigate employment counseling, workplace policies, litigation, and the protection of systems and proprietary data. He's also a certified information privacy professional and a member of the firm's data security and AI groups, advising clients on data security, emerging technology, and navigating the legal risks and opportunities presented by AI. Excited to hear about that. Michael earned his JD from Marquette University Law School in 2013 and lives in Wauwatosa with his wife and their 3 rowdy boys. And I hear he's about to go on an awesome trip out of the U.S. Welcome, Michael. Out of the mainland. Yeah, sorry, Puerto Rico. Let's just get it out there. Welcome, Michael. Thank you.
Thank you, Andy. When we originally set up the timing for this, I had a flight planned for 8 p.m. I was going to take the red eye. I got to get back to the front end here of my slides. Was going to take the red eye, but was able to reschedule it for tomorrow. Luckily, I'm excited to go for that. So thank you all. Thanks, Andy, for that kind introduction. And thanks again for attending, everyone. For my portion of the event today, I'm going to be talking basically about the legal side of retaining top talent. Some best practices that you can consider from an employer's perspective. What are some tools in the employer's toolkit? That's an analogy I'll return to a couple of times today. And then as we move forward, a high-level overview of some issues that do impact key employees, AI, FMLA, and non-competes, which we'll touch on kind of throughout the presentation, but we'll focus on towards the end. So to begin then, just why does key employee planning matter? It's fair to say this is an uncertain time in the economy. There are talent shortages across a lot of industries, and it's harder to find top talent, and it's probably even harder to retain the top talent that you already have. Ever since the COVID-19 pandemic, there's been an increased mobility for professionals to jump ship, even as a lot of employers have encouraged or required those people to work from the office. These are also employees that typically require a greater degree of data security consideration. These are people who often have the sort of keys to the kingdom access to the most important pieces of confidential information that you might have as a company. And losing them in that regard is not just a vacancy, it's really a material business risk. So there are legal considerations that we advise employers around to avoid, that they can build into contracts to avoid those risks from arising. So some of these may be obvious, but who are your key employees? These are people whose continued service is disproportionately valuable to the company. Revenue generators, top billers, your rainmakers, individuals who have specialized knowledge that's particular to the company, holders of the client or customer relationships. Who does the client think of when they think of your company? It's not necessarily the owner, it's not necessarily the manager, it's the client relationship manager. Or other people who are critical to operations and culture, who are the people who know how the Coca-Cola formula is made. Not everyone, it's very tightly sealed. The people who develop it and keep it internally, those are important people, even if they're not the ones selling it to the distributors. It's important to identify these key employees early for things like succession planning, continuity, general risk management, and compensation alignment, which Andy also touched on. But so then the challenge becomes, how do you build security around key employees without ensuring or without creating kind of endless job guarantees? A lot of us can probably think of an employment contract, but we may default to thinking that this is a contract that has a term on it. You know, this is a 1-year contract. This is a 2-year contract. So the challenge is, how do you get security for these people without allowing them to work forever, without kind of giving them a job guarantee? So what I want to focus on for this portion of the presentation are the options and the versatility that an at-will employment agreement with key employees can provide. And as a kind of level setting initial point, let's just talk about at-will employment just for background. At-will employment, it's the default rule in most states. This is the rule that says either party, the employer or the employee, can terminate the employment relationship at any time without notice for any lawful reason. So if you just are having a bad day and decide to terminate an employment relationship, not necessarily a good idea, but probably legal. All right. Question is going to be, what does your proof look like? And what is the employee going to allege is the real reason why they were terminated? In fact, Montana, the only state that does not default to employment at will. The benefits to the employer are probably obvious. Allows quick separation when necessary, helps avoid claims of lifetime employment by an employee, and it reduces litigation over questions of whether or not someone was terminated for cause. It provides this flexibility for organizational changes when positions have to be eliminated too. However, it requires clear disclaimers. Disclaimers of the at-will employment relationship are important to include in places like offer letters, often the first piece of evidence that we'll look to if a litigation matter comes up, handbooks, policies, and even performance reviews, performance improvement plans, because if you're put on a 90-day PIP regarding your performance within the role, it doesn't mean you're necessarily guaranteed employment for that 90 days, and that's a disclaimer we often recommend gets included. Avoiding contradictory language is obviously important. So no promises of permanent employment, especially not in writing, and no statements implying continued job security for employees. This is important to train your managers on. Employee managers who send emails or even make informal statements about guaranteed employment or their future can undermine the at-will status potentially. And because sort of a best practices standpoint, performance reviews and issues that arise with these employees should be documented and, to the extent possible, tied to objective, measurable criteria that a third party would be able to value and basically be able to measure how well somebody was performing in their job. So then, if employees are at will by default, what's the purpose, what's the point of using an at-will employment agreement? So again, employment contracts, they don't require a term. You don't have to have a 1-year term. You don't have to have a 6-month term, a probationary period that's built into a contract. It does not have to guarantee employment for 6 months. They can instead provide for at-will employment throughout the entirety of the employee's relationship, regardless of how long they work, whether it's 6 months, a year, or 15 years. At-will employment agreements can also provide the flexibility to offer a blended approach. So what happens if an employer does terminate an employee for cause, as defined often in the agreement? And what happens if the employee terminates employment on their own, or the employer just decides, hey, we have to let you go for XYZ reason, not your fault, but we are letting you go? You can set up what are the outcomes? What is an employee owed? Is there severance owed? What are the circumstances that they have to do to get that severance? Those are all things that we can build into an at-will employment agreement. But here's the key here on the right side. Outside of an at-will employment agreement, the simple at-will relationship, it does not offer protections for things like company property. Agreements can expressly require employees to return all company property upon their separation. Property is broadly defined. Property includes things like files, data, customer lists, information. So that is much harder to do. It's much harder to get a court to enforce a return of property obligation if it's only coming from basically criminal law, saying, hey, my employee left and they stole this property. It's much easier for a court to enforce a contract that says parties agree that property is defined as follows. They still have my client list. Court, make them give it back. Data security is another thing that can be an acceptable use policies. This is something else that we can impose in the at-will employment agreement. For example, affirmative duties to use encrypted means, the company's encrypted means that we make available to transmit certain information. And we can build in confidentiality obligations both during and after employment for things like trade secrets, client and customer data. We'll talk about it later on, but this is also the point where we'd say, the at-will employment agreement can itself be the vehicle for the non-compete, the vehicle for the non-solicitation agreement. Handbooks, by contrast, do not offer these protections to the employer. So from time to time, I'll have a company come to me that says, hey, this person just left. We think they're trying to poach our customers. They've gone to a competitor. Our handbook says that they're not allowed to misuse their company information. Can you send them a cease and desist letter? Generally, the answer will still be yes, I can send them a cease and desist letter, but we're probably not going to be relying on the handbook. Handbooks are uniformly not contracts. And if you take a handbook to a court and ask the court to enforce the handbook, the court's going to say that the power of that handbook stops at the end of employment. The handbook is there basically to allow you to discipline an employee, to make sure an employee is abiding by the terms of employment, or to terminate, but not to enforce on a third party sort of after employment. So then on the carrot side of things, there are also retention tools that we would say work well in the at-will employment context. Andy's presentation is essentially an elaborated version of a lot of things that could work well in the employment at-will contract. Stay and contingent bonuses, deferred compensation plans, equity and phantom stock equity programs. Clawback provisions tied to competitive activity. So if someone is disloyal during their employment, maybe there are provisions that specifically authorize the company to recover specific amounts of money that are tied to certain compensation levels. And other performance-based compensation frameworks, items that can also be maintained in a separate plan. So a lot of times what we'll have is we'll set up a sophisticated employment agreement for an executive, but their compensation plan will actually be maintained separately. And so every time if there needs to be a renegotiation of the employment contract, you don't have to go back and renegotiate the specifics of the compensation plan every time. Other contractual protections that the at-will employment agreement can offer and be that vehicle for. So confidentiality agreements, we mentioned this. These are ones that I would say are outside of the traditional non-compete context. And why, you might say, are these going to come up? Well, that's because, as Andy mentioned, a lot of companies are concerned about the enforceability of what you might call a traditional non-compete. When an employee leaves, are we allowed to prevent them from competing within 30, 50 miles within the state of Wisconsin, et cetera? So these are other tools that are also related to a non-compete agreement: confidentiality agreements, client and employee non-solicitation agreements. Those two in particular, just to focus on, they are like the non-compete agreements, governed by the same Wisconsin statute. There is a statute in Wisconsin, 103-465, that governs how and whether those are enforceable. So it is important, if you had a confidentiality agreement or a client or employee non-solicitation agreement, that you consider whether or not it's properly limited, and we'll get into those details, and compliant with the statute. But other things that can be contractual protections for the company brought into the at-will agreement are things like intellectual property assignment clauses, to make sure if someone is developing IP in the evening with your IP, then that's, by virtue of the contract, something that they are required to assign to the company. And other things like garden leave style paid notice periods. You got an executive who is leaving, and rather than try to enforce a non-compete, you basically continue to keep them as an employee, but they're on a garden leave where they're just hanging out. They're getting paid, but they know that they have an existing obligation not to compete with the company. So a lot here, and obviously those are not the only things that get included in an at-will employment agreement. My goal really is for you to leave this presentation understanding that at-will employment agreements are sort of like a Swiss Army knife. They're a tool. They're a toolbox with lots of tools inside, to blend the analogies here. And it's something to consider using for key employees, where you can both include the carrots and you can also include the sticks. So Next topic, again, we're going to give a high-level overview of some additional kind of best practices of issues from a legal perspective that can impact key employees. So I'm going to be covering artificial intelligence, very high level. Happy to answer questions after the presentation. And then we'll be covering FMLA, considerations for key employees, as well as non-competes. So how do you strategically use AI to book key employees efficiently? So I would say this is something to just keep in mind, that it is an assistant. It does not replace the top talent. However, it's critical to allow your top talent in particular to become more efficient with the stuff that is not revenue generating, with the stuff that they could, pass off to an AI system, reduces the administrative and repetitive tasks, can automate some types of drafting, data analysis, and it frees them up for the more important things to focus on, like relationship building and business innovation. So using AI to protect business information, again, AI tools can support things like data monitoring, anomalous behavior detection. So these are issues that programs like CrowdStrike and other platforms that are doing kind of frontline data security, they are rolling out AI tools that can do some of these things and prevent us from needing to constantly work with an IT professional to make sure that we're keeping our documents safe. But there do need to be, guardrails for safe AI adoption. So there needs to be a clear internal AI use policy discussing what tools are approved and what's the process for an employee to get additional tools approved. When I talk to companies about this, it's just kind of think about it from the employee's perspective. If they've got this tool that's being marketed to them, do they know that they can't use it? Do they think that they can? Do they think that they can use publicly available, programs like ChatGPT? These are things that you would want to define within an AI governance policy and tool. And also, please give consideration to whether systems are closed versus open. Generally, if things are open, like the online available systems, those are ones that by default are training those models on the confidential information that's being put into it. So generally speaking, if you have contractual or insurance obligations to maintain secrecy around any type of data or information, you'd want to put some limits on what public systems employees are allowed to use within the scope of their employment. But other additional guardrails that are important to consider: vendor requirements like encryption, retention limits, and confidentiality. So this is the vendor that's supplying you with the AI technology, for example. And a lot of times we recommend even requiring vendor audits. And then generally requiring, especially key employees, get trained on responsible AI use. So now we're on to the final portion of the presentation here. We'll talk about some legal guardrails. I'm going to try to go quickly through the FMLA. That's an area that has a particular exception for key employees that I want to hit on, but I'm not going to give you a long conversation about FMLA. I sat through an entire hour presentation just about the FMLA this week, and I'm certainly not going to go into detail to that extent. But in general, it applies to employers with 50 or more employees on the payroll for 20 or more calendar work weeks. Eligible employees to take FMLA must have worked for at least 12 months and 1,250 hours before they can request leave. It also only applies to employers who have at least 50 employees in general and at least 50 employees at one work site or within 75 miles of one work site. Employees can take 12 or more weeks under the federal law for their own serious health condition of a spouse, employee, or parent, birth, adoption, or foster placement, as well as some exigency leave for military family members. So employee rights, though, during and after FMLA, kind of as a baseline before we jump into that FMLA exception for key employees. So leave may run concurrently with paid leave. Federal law allows the employer to require an employee to use their PTO that's available, their vacation pay that's available concurrently so that someone is getting paid for that time. Otherwise, by default, the federal law does not require an employer to pay an employee during their FMLA leave. It also, the FMLA, the federal law also allows an employee to return to the same or to an equivalent position, and it protects the employee from retaliation for requesting FMLA leave, for using FMLA leave, or for otherwise kind of opposing FMLA discrimination. So here's the main thing I wanted to focus on here. There is a difference between federal and Wisconsin law as it pertains to key employees in particular. This does not come up that often, and I would say if you're considering exercising the federal exemption on key employees, which is, I don't want to bury the lead here, the federal exemption is that the federal law does not require an employer to bring a key employee back to the same or equivalent job position. It doesn't require you to maintain the position for them after employment. And this is top 10% of earners if returning them to work would cause a substantial and grievous economic injury to the company. But if you're planning to exercise that exemption, please contact me or another lawyer before you do so. It's a very, very rarely used exception, very rarely litigated. And so it would be very important to make sure that your proof of whether or not something was a substantial and grievous economic injury was kind of up to snuff. But the reason for this is that a lot of times, say you're replacing, or say that a CFO goes on extended FMLA leave, there's going to be a significant deficit in the human capital available to the employer, and they're going to need to replace those skills in some way. If the only thing that they can do is hire another CFO, well, then you can't necessarily have two CFOs. And so that's where the question comes in. Do we exercise this federal exemption? However, critically here, the Wisconsin FMLA, again, this is the difference between the federal and the state law. This is not the only one. It's the only one I'm going to focus on, though. The Wisconsin FMLA does not include an exemption for key employees, but Wisconsin FMLA only allows someone to take 2 weeks of protected Wisconsin leave as opposed to the 12. All right, so last topic, restrictive covenants in 2026 for key employees. As I mentioned earlier, Wisconsin Statute 103-465 is the law about how Wisconsin courts have to interpret restrictive covenant agreements. These are, like I mentioned, your traditional non-competes that are often related to a specific geography, but can also be tied to a customer list. But these are also non-solicitation agreements with a particular list of customers or with a particular set of customers, those that are important to the employee relationship that were developed during employment. And this does also apply to confidentiality agreements in Wisconsin, which is actually kind of a unique facet of Wisconsin law. A lot of states do not apply the non-compete law to confidentiality agreements. But here it's important to focus on reasonableness and narrow tailoring. The kind of traditional 5-factor test is they have to be necessary for the protection of the employer, provide a reasonable time restriction, a reasonable territorial limit, not be harsh or oppressive to the employee, not be contrary to public policy. What I tell companies and what I told employers even in the last week is that what I'm going to need to tell the judge is, why do we need this? Why is this restriction necessary for the protection of some kind of important interest? Usually that's customer relationships. But if you can sufficiently answer that question and provide evidence, then there actually is a significant amount of case law saying that you can enforce a non-compete, both the general type or the typical type of the radius restrictions and the non-solicits and the confidentiality agreements. So what I wanted to do is offer an example of recent case law that actually demonstrates the further reason to consider use of these agreements in some capacities. So the case was Fry Construction and Home Improvement versus Hoscheider Roofing and Siding. This is a case in which a company had an enforceable non-compete agreement with one of its top sales employees, and then the employee left, kind of this traditional fact pattern, unfortunately, I see a lot. Employee left to join a competitor, probably saying this is never going to be enforced. The employer is not even going to try. Left to join a competitor in violation of his non-compete and non-disclosure agreement. Fry Construction first took the employee to court over the violation of the non-compete and non-disclosure agreement, and at some point they settled that. But it wasn't until having expended quite a bit of money in attorney's fees to try and enforce the agreement. After, I mean, you'll see here that this is a company against the company that he went to work for. So Hochscheider was the company, kind of the new employer that he went to work for. So after they settled with the employee, they brought a lawsuit against Hochscheider Roofing, the new employer in this situation. The claim there is called tortious interference with contract. Basically, you competitor knew that he had a non-compete agreement and you hired him in violation of that non-compete agreement anyway. And what's really important that comes out of this case is it's the first case that we're aware of that a Wisconsin court has awarded attorney's fees as a measure of the cost that was required to enforce the non-compete agreement. So because the employer enforced the non-compete against the employee and had to spend attorney's fees to do so, once they then took the new employer to court, arguing that you knew he had a non-compete agreement and you employed him anyway in violation of it, then those costs were recoverable as the employer's damages in the original litigation, which is rare. Typically, attorney's fees are something that both sides just have to pay on their own unless there's some sort of fee shifting agreement that's built into the contract. So just to wrap up here, just some key takeaways. It's worthwhile considering who within your organization are key revenue and relationship drivers. Generally, those are going to be your key employees that you want to think strategically around, what incentives can we offer them to stay and what contractual protections can we include in something like an at-will employment agreement to encourage them to stay longer as well. Those employment contracts do not have to provide for just cause termination, though they can, or they can offer both avenues for the end of employment. You can simply use an at-will employment agreement to retain the flexibility. It's really a Swiss Army knife, holds a lot of valuable tools that you can incorporate into the agreement. AI adoption is here and it's coming for you and your employees. And it's important to consider, proper governance techniques, putting documents in place that outline how the company is planning to roll that out and any guardrails that you want to make sure that employees abide by while doing so. And then finally, the non-compete agreements, restrictive covenant pieces, they continue to be a mixed bag in Wisconsin. There's a lot of cases that come down where they're held to be unenforceable, but in other circumstances, we're able to generally negotiate a good resolution for a client through trying to enforce a non-compete or, even enforce it through court. So with that, thank you very much for your kind attention. We really appreciate it. Does anyone have any questions for me that they're just dying to get out at this moment? No, it's fine. If you think everybody would love to hear, go for it. Yeah, so I don't think the lawsuit discussed whether I think they continued to work for the new employer. So there was, the employee continued to work in violation of the non-compete, even though they settled the litigation. And so that probably continued to give reason for why the company went after the new employer. But generally, you'd want to resolve the thing. The settlement itself was confidential, and generally, you'd want to resolve the things by, having a signed settlement agreement with the employee, and then kind of at the same time working out an arrangement with the new employer, maybe to amend the terms or something so that all parties can be comfortable with the existing relationship.